Hello everyone, this is Tom Fox and I'd like to welcome you to episode 80 of the FCPA Compliance and Ethics blog. This episode is part one of my interview with the FCPA professor on his new book, Foreign Corrupt Practices Act in a New Era. I apologize in advance for the crummy audio on this, but I hope you'll sit through it, it's excellent. Compliance and Ethics Report. Today it is my distinct pleasure to have back my good friend and colleague, the FCPA professor, also known as Mike Kaler, and today we are going to visit with him about the book. The professor has come out with what I think is going to be one of the standard texts on the FCPA for many years to come, and I asked him if he would come on and visit with us about the book, kind of his process for writing it, what led him to write it, and what he's trying to communicate with it, and how we might use it going forward, both from people like yourself as a professor, students, myself who are nuts and bolts compliance practitioners, in-house practitioners, and anyone else interested in this law. So with that very long-winded introduction, thanks a lot for joining me again, Professor.
Well, thanks for having me, Tom, and I'm happy to have this opportunity to talk about the book. And regardless of what anyone may think about the substance of the book, I think we'd have to agree that at least the cover of the book is perhaps the most captivating cover on an FCPA book there ever has been.
Well, let's show our fans the cover of it again, because it's an excellent cover, and as good as the cover is, it's really what's inside that I think is the most important. So, Mike, if I could start out by asking what led you to finally sit down and write a hardcover textbook? And I ask that not because you don't write, but because the opposite. You're one of the most prolific authors in this field, blogging every day, writing numerous scholarly articles, and a wide range of other interests.
Yeah, it's probably no surprise that a person who has written about the FCPA on a near daily basis for 5 years was at some point going to sort of put that all together and synthesize it, between two covers. So it has been always sort of a goal of mine to do this. I learned through the process that the publishing process is not as quick as putting up a post on your own website, to be sure. But, it's a logical extension for me and a way to capture between two covers many of the big picture points I have been really talking about in this space over the last 5 years, and was grateful for the opportunity of the publisher and the reception it's received thus far.
Suppose not refer to it simply as a book, but you give it its full title. What's the title of your book?
Yeah, the Foreign Corrupt Practices Act in a New Era, and sophisticated observers will probably know that is a playoff of the November 2010 declaration, statement, what have you, of the Department of Justice, that we are in a so-called new era of FCPA enforcement, and we are here to stay. That was a direct quote of the DOJ's former Assistant Chief of the Criminal Division.
I'm afraid I already have to take issue with something which you said, which was to imply that this book is a compilation of your prior work. I would really have to disagree with that. It may have formed some basis, but you put a lot of new material in here, because I was one of the devourers of your work. So you may have some of your stuff you've done, but you put a lot of material in here. I'd just like to ask you, though, how would you envision or suggest that this is used in teaching?
Yeah, we're all lifelong learners, right? Just because you graduate from law school or business school, your learning is not done. Just because you may be a partner in a law firm or reach the executive suite of a company, your learning is not done. And this book is not a traditional law school textbook, as is quite clear from just thumbing through it, but rather it is a book that can be used in law schools and business schools and MBA programs. But I really wrote it for a number of audiences: the classroom, the courtroom, the policy room, and lawyers' offices, where they can use it sort of as a resource guide. And I don't think that objective in writing the book was casting the net too widely. Because like I said, whether you're a student coming to this for the first time, or a lawyer coming to this for the first time, or regardless if you already have a base level of knowledge, there is information and tools and practice pointers and knowledge in this book that you are likely going to be encountering for the first time. And it's never too late to learn. We're always lifelong learners, and this is an evolving, area of practice where just because you may have known all that was needed to know 5 years ago, it's changing. And I'm already thinking about, well, this book is on some level dated because, this is a changing area of law. The book was written before the 11th Circuit for an official decision, before the cert petition that is currently pending before the Supreme Court. So maybe in a couple of years we can revisit about volume 2.0 of the Foreign Corrupt Practices Act in the new era.
Was there anything that you discovered in your research when writing the book that you had not been previously aware of, was new or different, or caused you to maybe look at something different?
As frequent readers of my website probably know, I dive into the details on a lot of topics. Obviously, there are other websites and practitioners, covering the FCPA enforcement, but I'd be the first to admit that as a professor, I have the luxury of spending more time in doing the research and digging into the history of the law, digging into some of the arcane policy statements that the DOJ and the SEC may have made, in the 1980s, 1990s, digging into some FCPA enforcement actions that were actually subjected to judicial scrutiny, albeit in a different era, in the 80s and 90s. And bringing that to the front and making current practitioners aware of this is, call it what you want, but I sort of view it a public service that I'm able to provide just because I do have time on my side in taking a deep dive into a lot of these topics.
Is there anything that you were able to explore more thoroughly, fully, or even deeper in this book that you hadn't been able to in other publications?
Yeah, I think for obvious reasons, much of the focus of the FCPA is on the anti-bribery provisions. But let's not forget the FCPA also contains books and records and internal control provisions. And one can debate and perhaps disagree as to the current level of aggressiveness as to DOJ and SEC enforcement of the anti-bribery provisions. When you really take a look at legal authority and non-legal sources of information, though, relevant to the books and records and internal control provisions, is really revolutionary and evolutionary what the SEC in particular is doing in terms of enforcing the internal control provisions and the books and records provisions. So a lot of people say, well, there was no guidance on the FCPA until 2012. That's just not true. The SEC put out extensive guidance as to the books and records and internal control provisions in the 1980s. And it is very difficult to square what is being said in that guidance as to a statute that really hasn't changed in many of the current enforcement theories that the SEC is advancing in books and records and internal control cases.
And I guess we would probably say that even since you wrote the book, and maybe even since publication, the SEC has continued to evolve because now they are not filing court cases, but generally prosecuting cases administratively, which opens up another conundrum of questions that none of us really know the answers to.
Right, you're exactly right. And for instance, in 2013, 50% of SEC enforcement actions in the FCPA context were not subjected to not 1 ounce of judicial scrutiny, either because the SEC used an MPA in the case of Ralph Lauren, but more significantly, as you note, the increasing trend and the SEC's vow to pursue this trend of handling these cases administratively. I think it raises a tremendous number of public policy issues, rule of law issues, due process issues, and other people are talking about this as well. One of the leading commentators on this is Russ Ryan at the law firm King and Spalding, who had a Wall Street Journal editorial a couple of weeks ago. Judge Rakoff, in his recent final approval, actually put in a footnote what I've been saying all along about the use of this administrative process. It raises some significant concerns, and it should be looked at in greater detail.
Let's turn to some of the specific topics in your book. The first one I'd like to explore with you is something you've identified as the 3 buckets. And obviously many practitioners are aware of fines and penalties. Those are public record and are well documented. Occasionally you find out about the cost a company may have, a public company at least, may have engaged in an investigative or remediation effort. But that's not even the complete cost of an FCPA incident, if I can use that term. Talk about the 3 buckets and why you think it's important for practitioners to understand that.
Yeah, I mean, this is a hugely important issue because, at the end of the day, whether it's investors in a company or whether it's, the company's executives themselves, they care about spending money and not necessarily if the money goes in that bucket, this bucket, or that bucket. And approximately 2 years ago or so, I sort of coined this term, the 3 buckets of FCPA scrutiny as well as enforcement. And bucket number 1 is pre-enforcement action professional fees and expenses. Bucket number 2 is what I'll say is enforcement action day, the fines and penalty amounts that are reported in the media that lead the headlines in the DOJ and SEC release. And then bucket number 3 being post-enforcement action professional fees and expenses, as well as other negative collateral business effects of FCPA scrutiny. And why this is such a hugely important issue is bucket number 2, fine and penalty amounts, it's not the biggest bucket in virtually every single case. Sure, it gets the most media attention. Sure, it gets the most analysis. But the largest bucket in nearly every case is bucket number 1, pre-enforcement action professional fees and expenses. Why? FCPA scrutiny often leads to a company conducting a worldwide review of its operations. That involves lawyers, it involves forensic accountants, that can often take a number of years. And bucket number 1, where a comparison is available, because not all publicly traded companies disclose their pre-enforcement action professional fees and expenses. What you're seeing is that bucket is to a ratio 3, 5, perhaps 7 to 10 times greater than bucket number 2. And if you're a compliance professional, how can you use this information? I don't think it's very successful for a compliance professional to go to the board or to go to the other people in the company who may be holding the purse strings and say, hey, we need to invest in FCPA compliance because we could be the next Siemens. Sure, Siemens paid $800 million, the largest of all time, but does that really resonate with the business leaders who are making these business judgments as how to allocate the corporation's resources? I don't think that's as effective as saying, okay, if we are the subject of FCPA scrutiny, we're going to be spending most of our money here. This is going to be a gray cloud hanging over the company for 3 to 5 years. Even after the enforcement action is resolved, we're probably going to be spending millions of dollars more. There may be a hit to our market capitalization. There may be a hit to our credit rating, so on and so forth. Now a compliance practitioner is talking in business terms that is going to resonate more, I will submit, with the people who are making the business judgments as to allocation of corporate resources. Just saying we're going to be the subject to a DOJ and SEC enforcement action, sure, that may get you somewhere. But I think in terms of advancing the ball and taking a more holistic view of FCPA scrutiny and enforcement is a healthy exercise. And that chapter is intended to shift the conversation away from FCPA enforcement and FCPA compliance just being a legal issue. Because when you're talking about the DOJ and the SEC, we're talking about law enforcement. We're talking about legal issues. This is a business issue, as demonstrated by those 3 buckets of FCPA scrutiny.
Let's talk about bucket number 3, because that's one I don't think, or I think is rarely touched on. Do you have any sense of the ratio of costs or how a company might, or compliance practitioner might be able to factor that into some sort of presentation he would make to a board?
Yeah, first of all, an important point here is that a comparison as to all 3 of these buckets in a particular case is very difficult. Because again, not all companies are disclosing bucket number 1 or bucket number 3. And even in situations in which a company is disclosing bucket number 1, they may not be disclosing bucket number 3. So how are you able to make that ratio? Now, having said that, and potentially that, data limitation, even in garden variety type FCPA enforcement actions, I'm talking about ones that are not even remotely close to the top 10, to the top 20 in terms of fine and penalty amounts, you are seeing $3 to $5 million per year, if not more, in post-enforcement action professional fees and expenses. As you know, nearly every resolution vehicle contains compliance obligations and reporting obligations that a company may have for an 18-month to 3-year period. That's not to mention perhaps actual appointment of a monitor. Right. That obviously adds up. And then not to mention, and I'll sort of put this in bucket number 3 because it's a collateral impact as well, it's a high degree of probability nowadays that if a company is the subject of FCPA scrutiny or after an FCPA enforcement action is resolved, they're going to be hit with securities fraud lawsuits, derivative suits against officers and directors. Now, very few of these cases get past the motion to dismiss stage, but companies, not surprisingly, may settle these for nuisance value, recognizing that nuisance value can additionally be a couple $1 million, here and there. Right. So the takeaway point, I guess, is, just because there's an enforcement action, the company is still going to be spending money in connection with the scrutiny and the enforcement and the post-enforcement compliance obligations.
So I guess the takeaway would be the fines and penalties are not minuscule, but certainly a much smaller part. Companies need to think through the whole, not a picture of what their costs would be in such a matter.
Right. If a business leader, if an in-house counsel, if other professionals are viewing FCPA merely through the narrow prism of DOJ and SEC enforcement, it's not a realistic, holistic, sophisticated view. Now, there's also another, takeaway point too. Bucket number 1 is a fact, a demonstrable fact. But you also need to ask the question, does Walmart still need to be spending close to $700,000, $800,000, $900,000 a day on its FCPA scrutiny? So part of the discussion in the book, at least as to bucket number 1, and indeed as to bucket number 3 as well, is, on some level, this sort of looks like it becomes a boondoggle for a lot of different people, right?
Well, I would agree with the boondoggle part, but it certainly portends a very high level of accountability and scrutiny. And I guess I would only add that probably neither one of us could quantify the cost to a company, the soft cost of having executives who have their own lawyers, document production, all of the things that they're not pre-litigation, but they're certainly costs the company's going to have to engage in to get ready for any investigation that any litigator would be aware of.
No, and that's a good point too, because these 3 buckets are tied to actual measurable dollar amounts. Also discussed in the book on this topic is the unmeasurable, like you just said. You now have an executive who, instead of advancing the business and expanding market share and coming up with new products is really being distracted now in a significant way by the FCPA issues. Indeed, Walmart, among its many disclosures it's been making over the last couple of years, was the spot-on disclosure that, hey, because of this, our executives are not focused on what they're normally focused on. And how you measure that, it's very difficult, but you're absolutely right. That is an additional collateral consequence of going through this whole process.
Turn to potential amendments to the FCPA. You've written and spoken quite a bit on your you see a need for a pending compliance defense, but I would like to ask you a couple of questions. Number one, are there other areas or specific provisions that you would suggest amendment to? And number two, how can the debate, not the debate, that's the right word, how can we get Congress sort of re-engaged in actually looking at this in a substantive way, above and beyond people like you and me writing and talking about it?
Yeah, the book, its final chapter is devoted to FCPA reform, but there's additional nuggets of reform sprinkled, throughout the book. I've been a very vocal advocate, proponent of an FCPA compliance defense, which would actually make the FCPA consistent with the FCPA-like laws of many other countries. Just yesterday, I was looking at New Zealand's amendments to their FCPA-like law, and guess what? There's a compliance defense in New Zealand's law. So let's go with the Kiwis, right? Another one is not statutory because there is absolutely no authority in the FCPA or no congressionally authorized act that allows the DOJ and the SEC to use MPAs and DPAs to resolve FCPA enforcement actions. I would abolish those, and I've written extensively in the book covers how when you couple a compliance defense with abolishing MPAs and DPAs, I think you will get a resulting enforcement landscape that is more fair and indeed more effective in accomplishing the objectives of the FCPA. Another sort of reform proposal that I've talked about and other people have talked about too is to get rid of this really overlapping double dipping concept of the SEC enforcing the anti-bribery provisions. It's a historical fact that the SEC never wanted to get involved in enforcing the anti-bribery provisions. But Congress, congressional leaders in the mid-1970s had such a dim view of the Department of Justice that they didn't want to have an exclusive enforcement of this sensitive law just within the Department of Justice. I think post-employment restrictions upon FCPA enforcement attorneys with supervisory and discretionary power could serve several valid and worthwhile policy objectives. So there's a lot in the book, both in the concluding chapter and sort of sprinkled throughout, into why I think and how I think the FCPA can be made better. One of my biggest surprises in talking about the FCPA as frequently and vocally as I have over the last 5 years is some people call me the anti-FCPA professor, which, I take offense at that, obviously, because why in the world is talking about legislative history, actual legal authority, and how to make the FCPA better so that it can accomplish the worthwhile and laudable objectives Congress had? How in the world can that ever be viewed as being anti-FCPA? It really just floors me. I testified before Congress in 2010 that I firmly believe the FCPA is a fundamentally sound statute, but it can be made better. I think enforcement can be made better, smarter.
How about, have you thought about some ways to get Congress to start taking a look at this? Certainly you talk about it, I talk about it, others talk about it. We've seen some editorials in the Wall Street Journal, and certainly in our field, commentators speak speak on this issue, but we don't seem to see much enthusiasm or certainly any action out of Congress, at least I'm aware of. Any thoughts on maybe how to re-engage Congress?
Well, I mean, let's face it, things happen on Capitol Hill or don't happen on Capitol Hill, not necessarily because of substance, but because of optics, right? And, you know, I'll just use sort of the following historical fact. On one level, you could say that FCPA reform is dead, but I'll just sort of remind everyone that while the FCPA was amended in 1998 along the margins, the biggest period of FCPA reform was the 88 amendments. That whole process started in approximately 1980. It took 8 years for that to play out. Now, you know, we can't predict what's going to happen over the next 4 years, but I just wish there could be an issue-based substantive discussion about FCPA issues, but it's very difficult. And the reason it's difficult is because this is a law called the Foreign Corrupt Practices Act. Indeed, this was such a sensitive issue back in the 1980s that there were efforts to actually change the name of this law to something like the Business Accountability and Transparency Act so that an issue-based discussion could take place. Because no matter how much consensus there is amongst knowledgeable and experienced folks who actually have experience with the FCPA, and I would add that some of the most vocal proponents of FCPA reform are people in the DOJ who actually used to enforce this law. There will be civil society groups, NGOs, and other public interest organizations who know very little about actual FCPA enforcement, who will say this is waving the white flag of surrender to bribery, so it's a very difficult issue. I acknowledge that. But just because, and I'll quote sort of one of my favorite quotes from FCPA legislative history, just because the FCPA may spotlight a sensitive issue, it shouldn't cause us to turn a blind eye to its potential shortcomings and have an issue-based discussion as to perhaps how it could become better.
Mike, I'm afraid to say we're nearly at the end of our time, so perhaps I can get you to come back for part 2 because I only got through about half the short list of questions I wanted to ask you. I'm going to show everyone the beautiful book cover again, but I'd like to ask to end, if somebody wanted to purchase this, where would they go?
Yeah, I mean, it's widely available, including on my website, fcpaprofessor.com. You'll see at the upper banner, there's a books tab. You can go on Amazon and just Google the title there, and you'll find it. And thank you again for the opportunity, and I'd be happy to do part 2 at some point because, you know, I think there's, you know, consistent with the teaching objective of the book for a broad audience, there's a lot that needs to be said and people need to learn, you know, about the FCPA and FCPA enforcement in this new era.
Okay. Well, thanks a lot.
Thank you.